This is your IP Minute for June 30th, 2025. Note that the views expressed are my own and are not legal advice. Today's topic, opposite arguments to keep doctrine of equivalence and avoid prior art. Yesterday's IP Minute revisited the doctrine of equivalence and a holding of Festo that the doctrine of equivalence is maintained if an amendment does not narrow scope. Thus, the argument to keep the doctrine of equivalence is that an amendment does not narrow the scope of the claim. This is close to the opposite of the argument to avoid prior art, that an amendment does not broaden the scope of the claim. Since the vast majority of responses involve avoiding prior art, it seems almost unnatural to argue an amendment does not narrow the scope. A practitioner's tip: when accepting allowable subject matter and amending to overcome a 112 rejection, consider explaining why the amendment does not narrow the scope, no matter how unnatural it seems. And that is your IP Minute for June 30th, 2025.